Georgia. We understand that there is a verdict in the trucker's girlfriend murder trial of Georgia versus Jason Palmer. Now, the jury allegedly filled out the form incorrectly, so we're waiting for them to go back, make the corrections, and come back into court. They had deliberated for about 2 hours and 15 minutes or so. Let's bring in our guest to talk about that case and the fact that it only took a couple of hours for them to deliberate. Still with us, trial attorney Lateef Gray. Lateef, as you just heard, breaking news, there is a verdict. There were some issues with the verdict form. They're going to fix that, come back out in just a bit. We'll take folks out there live. But your thoughts on 2 hours and 15 minutes of deliberations for that jury?
That means that one way or another, whether it's guilt or innocence, guilty or not guilty, the jury saw it clearly and quickly and didn't need much deliberation to decide. So I've seen it go both ways when it's quickly like this. I've seen it be guilty and not guilty. So what it is, we'll have to see when the jury announces their verdict. But these things happen.
You know, Kelly, I've absolutely seen it both ways. But when you have a case like this where I think there was a solid amount of circumstantial evidence against this guy, particularly how did the body go from Florida to Georgia? There's really no real explanation for it. He did take the stand and testify, but I think this short amount of deliberations, not a good sign for the defense.
I would say not a good sign. Or they listened to defense counsel who said there's absolutely no physical evidence in this case. They said no fingerprints. There was nothing under the victim's fingernails to show that he had anything to do with this. The defense counsel, I believe, said no bark, no bite, or something like that in her closing. So one way or the other, they were able to make a clear-cut decision here. It didn't take them very long at all. Yeah,
it's interesting. And Lateef, quickly, only got about 20 seconds or so. What do you think it is? What would be your choice for the guilty or not guilty?
Given what I've heard and read, guilty.
Yeah, I would have to agree. Kelly?
I would think they're going to come back guilty. The only thing would be is if there's some jurors on there that saw her as the aggressor. And thought, well, I don't know, and then thought he obviously didn't do it. She ran off on her own and somebody else did it.
Fair enough. All right, thanks to Lateef Gray for joining us this hour. Coming up, we're going to have that verdict for you in the case of Jason Palmer. So keep it here on Court TV, your front row seat to justice. Hello, and welcome back to Court TV Live. I'm Michael Ayala. We're going to begin with breaking news in this hour. There is a verdict in the trucker's girlfriend murder trial going on in Georgia. Jason Palmer is accused of stabbing his girlfriend, or sometimes on and off girlfriend, Jessica Goodrich, back in October of 2022. Her body was found in a wooded area near a truck stop in Georgia. All right. What we're doing right now is we're waiting for the jury to get back into the courtroom. Just moments ago, the jury came in with a verdict, and after 2 hours and basically 2 hours and 15 minutes of deliberations. However, there was a problem with the way they filled out the jury verdict form. So the judge sent them back. They're going to fix that, and they're on their way back into the courtroom. As soon as they come back in and that verdict gets ready to be rendered, we'll take you back in there live. I believe, do we have Sonny Slaughter? All right, we don't have Sonny Slaughter. We should be joining us in just a minute as our guest. Now, in this case, you're looking at Jason Palmer. Jason Palmer took the stand in this case in his own defense and testified. Actually, it looks like the jury is in the courtroom. Let's get in there.
Writing? Yes. And you signed it? Yes. And dated it? Yes. All right, if you hand to the bailiff, hand to me. Mr. Palmer, if you please stand.
In the Superior Court of Camden County, State of Georgia versus Jason Michael Palmer, case number SUCR 2024-000113. Verdict form: we, the jury, find as follows. Count 1, malice murder. On the charge of malice murder, we find defendant guilty of malice murder. Count 2, felony murder. On the charge of felony murder, we find defendant guilty of felony murder. Count 3, aggravated assault. On the charge of aggravated assault, we find the defendant guilty of aggravated assault. Count 4, concealing the death of another. On concealing the death of another, we find defendant guilty of concealing death of another. So say we all, this 29th day of August 20.
I wish to inspect the verdict form.
No, Your Honor.
anything from either side before I release this jury?
No, Your Honor.
All right. All right. If you retire to the jury room, please.
All rise.
I'll be at ease while we go release this jury, and then we'll come back in and discuss sentencing. Okay?
Judge, will you let them know they're allowed to talk to us about it if they would like to?
I will certainly let them know that what their rights are.
Thank you.
Your Honor, may I be excused from the courtroom for 2 minutes?
Certainly.
Thank you.
All right, so you're looking there at Jason Palmer. He didn't seem to react very much to the jury's verdict. Guilty on all counts, 4 charges being brought against him. Malice murder, guilty. Felony murder, guilty. Aggravated assault, guilty. And concealing the death of another, guilty in the death of Jessica Goodrich. She was 45 years old at the time. The defendant is 47. The top 2 charges, malice murder and felony murder, both expose him to life in prison without the possibility of parole. All right, my understanding now is that we do have our guest joining us on the phone to discuss is law enforcement and litigation consultant Sonny Slaughter. Sonny, thank you so much for taking out the time to be with us on this hour. I want to get your reaction quickly. After 2 hours and 15 minutes of deliberations, this Georgia jury finds Jason Palmer guilty of, again, malice murder, felony murder, aggravated assault, and concealing the death of another.
Oh, thank you so much for having me. I believe that the jury saw right through his testimony. They did not believe that he did not have anything to do with her death. This was a heinous case in the way in which he disposed of her body. I'm so glad that law enforcement took the time to do their due diligence and identify her quickly and determine that he was involved in her murder. This is a good result. Something that I think was necessary in this particular case.
Yeah, you know, as he took the stand and he was telling his story, basically that back in Wildwood, Florida, when they made a stop, she jumped out of his car after an argument that they had. It was pretty angry between the two. He said some mean things to her. She runs out, and that was the last time he saw her. I thought to myself, you know, he was very, very cold-blooded in the way he told that story. And it took him days, I think 7 or 8 days before he even told anybody that she had run away from his truck. And so the story didn't really resonate. And more importantly, he was laid over in Woodbine, Georgia for about 13 hours or so, plenty of time to clean up after himself. And the defense was arguing that there was nothing connecting him to the crime. Well, it was easy for this jury to see right through that and say, well, that's because he took the time to clean it all up.
Exactly. And, you know, the truck stops and where truckers are able to park their cars and take showers, and that's an in and out exit, entry there. It's easy to just walk in, people not notice you because there's so many truckers there at one time, and to clean up quickly. Also, he had a lot of access and a lot of time between what happened and where he was driving to. And
Hey,
you know,
Sonny,
just his whole
Sonny, I'm sorry to cut you
demeanor.
off, but my understanding is that things are going again in the courtroom. We'll get back to that
Okay.
answer in just a minute. Let's get back into the courtroom.
All right, we'll come back to order. All right, what is the, as far as the sentencing goes, does y'all want to proceed this afternoon? Would you rather do it tomorrow or a date certain in the future? I'm not sure what the defense's and the state's position is on this.
Your Honor, if I may, having spoke to the family of the victim, the circumstances of their traveling from Massachusetts, the strict parameters of sentencing regarding this particular conviction, given the recidivist nature of it, state requests that the defendant be sentenced today and now.
I did already discuss it with Mr. Palmer. We're not opposed to having the sentencing today. However, we do not agree with the state's assessment that they gave us a proper notice and aggravation of the sentence. If Your Honor recalls, they filed a 404B motion stating notice of intent to present other acts evidence, where they were requesting to be able to get into his prior convictions during their case in chief or during the course of the trial. This motion has one line that says, in anticipation of sentence, the state submits the aforementioned serious violent felony conviction for sentencing purposes pursuant to OCGA 1710 6.1. This was not a separate motion. I don't believe that they have properly given us notice in advance of trial of their intent to seek an aggravation of the sentence. But we are not opposed to going forward with sentencing today.
We had, at the hearing, I know when they said that they were not going to use his prior conviction in the trial of the case, in their case in chief, that they would only, even if he testified, they said they were not going to ask to do it, I guess. And so then they said they were reserving it to use it for sentencing purposes. And you're, I mean, so that was at a pretrial hearing that they said that on the record. I'm not sure, was that also in writing? Is that what you're saying? It wasn't in writing and needed to be in writing, or?
No, I'm saying it was in writing. However, because it was a one-line statement contained in a different motion, that being a notice of intent to present other acts during their case in chief, and was not its own individual motion that was unambiguous and clear of its intentions, which is often required by law, such as, and I haven't had the opportunity to actually pull up this case law, but in juveniles, when they are seeking to charge an individual as a designated felony, it has to be noticed and unambiguous. And I would believe that the law is the same on that issue. So as to that argument, that's what we're placing on the record.
May I address the court, sir?
Yeah.
Your Honor, this is not a juvenile court, and notice is not in any specific type writing that's prescribed and is sacrosanct. What the state has provided on the record at a previous hearing was that it was not only one line. The notice provided the previous convictions, the express nature of the previous convictions, which were serious violent felonies. Those are all articulated in this consolidated motion. I made that clear. It was a consolidated motion. It is not styled as a 404B. It is styled as notice of intent to present other acts evidence. Your Honor, that can be construed generally and specifically by the state in that we present that serious violent felony series of convictions for the purposes of sentencing. I made that clear to the court and counsel. Copies were filed, provided. I have my own copy of that. Notice was adequate. Your Honor, I would argue that notice was adequate with that writing, but also with the tendering of the certified copies of the convictions. This reference to juvenile court is not proper.
Let me ask you this, let me stop you right here. So if in fact, does either side have any witnesses they wish to tender for in sentencing for either aggravation or mitigation today?
No, Your Honor.
Your Honor,
Or is it what is the evidence that you tend to tender today?
Your Honor, it is the certified convictions, and I use the plural, convictions of the defendant for. May I announce them into the record, sir?
You may. I overrule the defense's motion at this time, and go ahead.
Yes, sir. Your Honor, the defendant is convicted in the state, or correction, the Commonwealth of Massachusetts. Case number 1 for carjacking. It is listed as 000139-1. The offense is carjacking. The defendant was found guilty. Armed robbery, case 000139.
What is the date of the carjacking? Is it one indictment? Is it 2 indictments?
Oh, it's one indictment, sir, with multiple felony convictions on it.
So under Georgia law, would that be treated as one conviction for purposes of recidivism treatment?
Yes, Your Honor, but under the statute, since it's a serious violent felony, and this is the second conviction on a serious violent felony, the code section expressly states that the defendant is to serve the maximum sentence under this conviction, which would be murder, life, without the possibility of parole. He would not be subject to parole at any time. He would spend the rest of his natural life, because the first conviction, regardless of whether it's a conviction in Georgia or anywhere in the United States, the recidivist nature of this conviction under the code section is that it is life without the possibility of parole.
Concealing the death, is that 1 to 5 or 1 to 10?
Would have to check that, sir. I apologize. I do not know offhand.
Your Honor, if I might be excused from the courtroom, I can provide you with that information.
I don't think that'd be necessary. I can pull it up right myself real quick on Westlaw.
I'll have it in 2 seconds when it loads. Oh, never mind. That was for Nevada. I'm already on Westlaw searching it, so I can have it in a few seconds.
And Your Honor, for the court's edification, the statute that is being referenced in question would be...
That's fine.
Okay.
161031. 1, no more than 10 years.
Okay. State needs to mark your indictment as an exhibit, please.
Yes, Your Honor.
Show it to as the defense counsel has seen this.
Yes, Your Honor. It was attached with the motion.
Okay.
And filed in court.
Any further objections to it for purposes of this hearing?
No, Your Honor.
All right. It's marked as the state's exhibit number 1 for sentencing, I guess?
Yes, Your Honor.
All right. Submitted then. Anything from either side? Obviously, if the court is going to follow the law, then I don't have it. I know that count 2 would merge into count 1, and count 3 would merge into count 2. So I'm only making a sentence as to count 4 and count 1.
Correct. And I just want to make it clear for the record, I don't believe the carjacking is what qualifies as the serious violent felony. However, there was an armed robbery. I don't think Mr. Morose got that far into the conviction, but that is
The armed robbery
on his
would.
criminal history.
I believe I did announce it was armed robbery, Your Honor.
All right. Let me have that indictment, please.
Got something back from the Court of Appeal.
Your Honor, the court mentioned if any witnesses would be availed. I believe under the victims' rights, the victims would be allowed to address the court if the court saw fit to such.
Yeah, they have that absolute right to make any statements if they wish to make them at this time.
May I query the family, sir?
All right, we're going to step aside here, take a break. Again, Jason Palmer found guilty of all charges in the trucker's girlfriend murder trial. The parties agreed to move right into sentencing because of travel considerations. The family came up from Massachusetts. The defense said okay, but here's the kicker. He's going to be sentenced on malice murder and concealing the death of a body. For the malice murder, because it's a second violent conviction, he will be facing mandatorily life in prison without the possibility of parole. We'll have that coming up next. So keep it here on Court TV, your front row seat to justice.
Tonight on closing arguments, an accused quadruple murderer, Brian Kohberger, returns to the courtroom. What this hearing means for the trial slated to begin in the summer.
Closing arguments tonight at 8/7 Central, only on Court TV.
Join me for a Court TV true crime series where we take you from the crime scene to the courtroom in America's most compelling cases.
Victim to Verdict with Ted Rollins. New season premieres September 8th.
Only on Court TV.
We are continuing our coverage in the trucker's girlfriend murder trial in Georgia. Moments ago, the jury found Jason Palmer guilty on all 4 counts in the death of Jessica Goodrich. He stabbed her to death while they were on a trip driving from Massachusetts to Florida. So I want to get you folks back to court now where the judge is actually going to be issuing his sentence.
The jury having 2024 CR 113, State of Georgia versus Jason Michael Palmer. Jury having convicted you of count 1, malice murder, count 2, felony murder, count 3, aggravated assault, count 4, concealing the death of another. Court hereby adjudicates you guilty of counts 1, 2, 3, and 4. I sentence you to count 1. Count 1 on the Recidivist Act being a prior serious violent felony of armed robbery in another state. I sentence you to count 1 to life without the possibility of parole. As to count 2, I hereby that merges with count 1, and count 3 merges into count 2. I've adjudicated you guilty on those, but there is a merger issue. And as to count 4, concealing the death of another, I sentence you to 10 years, and that'll be consecutive to count 1. You have 4 years, date your sentence comes final under Georgia law to file a habeas petition. You have 30 days from the date I date, sign, and file the sentence to file a notice of appeal. You also have the right notice for a new trial or an appeal, or you could file a motion for new trial. You have a right to have an attorney, okay? And if you can either hire one or one will be appointed for you to represent you on appeal. I'm going to instruct your counsel now to speak with you about those rights and so that they're protected. Anything, I believe that completes the sentence or anything.
No, Your Honor.
The state will be responsible for drawing up the sentence and getting it to the court, okay?
Yes, sir.
All right. All right, so judgment of the court will be in recess.
All right, so there you saw Jason Palmer, convicted of malice murder, sentenced. He's basically what we call in the business a 2-time loser. He had a previous serious felony, so now the maximum sentence was the only choice for the judge, and that was life in prison without the possibility of parole on the malice murder of Jessica Goodrich. All right, let's bring in our guest here now to discuss. Law enforcement and litigation consultant Sonny Slaughter is with us, and here in studio, Court TV legal correspondent Kelly Craft joins us as well. Kelly, I'll start with you. I want to get your reaction to the guilty verdict. We discussed it last hour, 2 hours, 15 minutes for this jury. We both agreed it didn't look good for the defense.
Yeah, when a jury comes back this quickly and has a verdict that soon, you usually think guilty. I mean, you never know. But one of the things that I found surprising at first when they said they were going to go right into sentencing, but then when we started to talk about and realize that it's mandatory. And so when a judge has something that's mandatory, he cannot even divert down for extenuating circumstances. And so then defense counsel ended up agreeing that we might as well just get this over with and sentence him now. But usually in sentencing, we see someone putting on mitigating evidence, wanting to call witnesses of their own, maybe the defendant himself making a statement in allocution in which maybe he could talk about his remorse, but that did not happen in this case, again, because the judge had to follow what was statutorily required of him.
Absolutely. And Sonny, I'm not sure, as a defense attorney, I would not have wanted more time just to put things on the record. Again, we do know it was mandatory, but they agreed to go with it. Part of the reason family members of the victim traveled from Massachusetts to come testify, watch and be a part of the trial. Also surprised there weren't any victim impact statements. That's another thing that, even though we know what the sentence was going to be, it still could be cathartic for the family to get closure, being able to just say a few things in court. Your thoughts on how that played out?
I agree with both of you and everything. And it's really important to have victim impact statements, no matter whether the judge has discretion or not. But also, as you said, what's clearly missing in this component was getting things on the record, because he does have the option to appeal. Now, I don't know whether that will work, but constitutionally, we still need to follow the process. And there was a process in place to ensure that we follow the rules, the Constitution, and that everyone's rights are protected. So I don't know if this will have flashback later on. I'm sure he may try to appeal. Maybe his attorney will discuss that with him later. But I do think it's really important for the victims to have some kind of say in a courtroom. I've done it. It's very painful, but it is cathartic for the family, and they need something other than what just the court does, what they say for themselves and how they speak about their family member.
Yeah, no doubt about it. And just to be fair, we don't know if there was discussions between the prosecutors and the family beforehand saying that if there was a conviction, do you want this opportunity to speak? They may very well have said, let's just get this over with and move forward at the end of the day. And just to clear things up, his prior conviction, he had a carjacking, but also for a violent felony armed robbery. These took place in 2003, Kelly, and he's 47 now. That may make him around 26 or so when he committed those armed robberies. I was interested in when it happened, because if it was something that happened when he was a teen, you could say, okay, it's not a good thing, but at the end of the day, he was a kid at that point. But he was 27, so it just makes you feel like, hey, this is a bad guy, two-time loser. He probably belongs behind bars for the rest of his life.
Yeah, most likely, Michael. And even when you heard defense counsel, they're trying to argue some case law, talking about bringing up some cases of juvenile court, and the state was making it clear, we are not talking about things that happened during a juvenile time period in someone's life. This person was an adult. They were talking about that in regard to more the notice, when the defense counsel was trying to say we didn't have proper notice that we were going to be going into sentencing and bringing up his prior convictions. But yeah, I mean, he just seems like he had a lot of bad things in his background, and frankly, just in general in this situation, they were in this on-again, off-again relationship for over a decade. Some abuse between both parties that came out on the stand, talking about how she had some violent tendencies as well. Obviously, had a disease. It appears she was an alcoholic. So just a messy situation all around. And now this man is going to prison for the rest of his life without the possibility of parole.
Yeah, we had talked a little bit about the fact that we're all sort of the sum total of the choices we make. He decided to go on this trip with this woman, didn't turn out well, and here he is now going to end up spending the rest of his life in prison. Once again, Jason Palmer, in the trucker's girlfriend murder trial, found guilty of malice murder, felony murder, aggravated assault, and concealing the death of another, will spend the rest of his life behind bars without the possibility of parole.